Uh, Ashley Scott is in the middle of a trial, and she still agreed to join us to present, so we're really fortunate for this. Our speaker, Ashley Scott, is a senior litigation attorney with Cordell and Cordell. She's been practicing for 11 years. She's given some excellent presentations around the city. She presented at Shell's National Coming Out Day on this specific topic. She's here to talk about adoptions. She's also presented at South Texas College of Law on same-sex marriage issues. So we're really fortunate to have her join us today. And Ashley, I'll let you take it from there.
All right. So like Daniel said, hi everyone, my name is Ashley Scott. I've been practicing almost exclusively family law for the past 11 years, with 3.5 of those years dedicated to about 95% practice in the LGBTQ+ community. So I'm really excited to talk about adoption today. It's a really, really important topic in this area of law. Families are created nowadays in many different ways, and unfortunately, I don't know that our Texas Family Code and our Texas law has really accounted for all of the different ways that families are now created. And so that leaves LGBT communities and families very vulnerable. So when talking about adoption, the first thing we look at is Texas Family Code section 102005, who has standing to adopt. Typically, a person has standing to adopt if they've had substantial past contact with the child. Most adoptions, parents are in agreement to file the adoption, so this isn't something that's typically brought up on an everyday basis. But if you were going to file some kind of contested adoption, then that would be something that you would want to look into. Second thing you need to make sure is under Texas Family Code section 162007 is who is eligible to adopt. What child is eligible to adopt? Is your client eligible to adopt this child? Is this child eligible to be adopted? So those are the two very basic first steps that you need to look into before filing an adoption. There's a few different types of adoptions that you can file. The first is a single parent adoption. That's when only one parent's going to adopt the child. So typically this comes into play if you're doing maybe an international adoption and the international adoption doesn't allow for same-sex adoptions. Typically only one partner will adopt in the foreign country and then bring that child back to the United States. Other times I've had clients in CPS cases where we weren't sure if the judge was going to grant the adoption to same-sex couples. So we had only had one partner adopt the child, and then at another time, the other partner would adopt. Or maybe you're in a jurisdiction where that particular jurisdiction won't allow for same-sex couples to adopt. So that's typically when you have a single parent adoption. You can also have joint adoptions. This is when both parties adopt simultaneously. So they're joint petitioners. Both parties are going to adopt the child at the same time. Second parent adoptions. This seems to be one that I did quite a bit in the LGBT community. This is when the child that's being adopted has only one legal parent. So again, this kind of stems from that single parent adoption when you're in a jurisdiction where the court will only allow one same-sex couple, one same-sex partner to adopt. Then at a later point, you do a second parent adoption where that second partner is now going to adopt the child. In a second parent adoption, you're not terminating any of the legal parent's rights. You're not stripping them of any of their rights. All you're doing is just filing an adoption to let that second parent now have legal rights over this child. I've also done second parent adoptions when a child has been conceived using assisted reproduction, when there's been some kind of sperm donor. Again, the child has one legal parent, and then the second partner is going to adopt, and now the child is going to have two parents. And the last one is a step parent adoption. That one I think probably speaks for itself, where the spouse of a legal parent is going to adopt the child. So since Obergefell decision came down, we now recognize same-sex marriage. So there are certainly situations when there is a step parent that wants to adopt the child. Maybe the legal parent had the child from a prior relationship. Maybe that legal parent had that child through a sperm donor, and now their spouse is going to adopt that child again, so the child now has two legal parents. So what's the procedure for filing the adoption? Whenever you file an adoption, you can either file just an adoption, or you can file a termination and adoption at the same time. If you're going to file the termination and adoption at the same time, typically what courts are going to do is they're going to hear the termination first. So they're going to make a determination to figure out if the legal parent's rights should be terminated. If at that time the court finds, yes, it's in the best interest of the child, there's clear and convincing evidence, you've met everything under the code, the court will terminate that parent's rights, and then a lot of times turn around and do the adoption. Judges like to have the children in the courtroom for the adoption. I think it's one of the only happy things that they get to see in their courtroom. So a lot of the judges like to have the families and the children, but they don't want the children in there for the termination. So that's typically why they do it in two different steps. So how do you terminate someone's parental rights? Well, it can either be a contested hearing. Typically, those take place again prior. A lot of times, I've had LGBT couples that are adopting children out of CPS. CPS would handle the termination portion, and then we would come in and handle the adoption portion. But you can certainly file a contested termination on behalf of your client and make it a private matter. If you have a parent that's willing to sign away their rights, then they can sign a voluntary relinquishment. Just need to make sure that the biological parent signs it after the child's birth. And I always caution my clients to remind them, since you're an interested party, they cannot be a witness to this voluntary relinquishment. That's a big no-no. You don't want to do that. You want to make sure that they have neutral third parties that are going to sign these voluntary relinquishments. I've had hospital staff that's been willing to do it. I've had clients that have brought in their own third parties that have been willing to do it. So you just want to make sure that your client is aware that they cannot sign off as a witness on this voluntary relinquishment. Other instances, if you have an unknown father. So when you have an unknown father, it's important that you still terminate their rights. And this is because if you don't want that unknown father coming back years down the road to say, hey, I was never served, my rights were never terminated, and technically you still have one legal parent. So what happens when you have an unknown father? The court's going to appoint an attorney ad litem to look for that unknown father. They're going to do their due diligence. They're going to talk to your clients to figure out if they have any information about who the possible father is. They're going to talk to the biological parent to figure out if that parent knows who the father is. And then the attorney ad litem is going to follow up on any leads. If they find the father, now you have to serve the father and bring them into the lawsuit, and they will have the opportunity to try and contest the termination. If the ad litem does not locate the father, then the ad litem will file their report with the court, letting them know that they've done their due diligence, and then you can typically move forward with your termination. You also need to check the Bureau of Vital Statistics to make sure that this unknown father, that no one has filed anything for parentage there, that no one has filed to say, hey, I'm the father. If you find a name on the Bureau of Vital Statistics, again, you need to bring that person into the lawsuit. If they have not registered and the child is more than 2 years old, then, or if they haven't registered, then that's grounds for termination. If you're going to file just an adoption, let's say the rights have already been terminated, now you need to file just an adoption, then there's no one else. It's just whoever the people are involved in the adoption, that's going to be the only parties that file that lawsuit. So when you file an adoption, in every adoption, home study is required. In Harris County, the courts utilize the Domestic Relations Office to conduct these home studies. Typically, this home study is done on a sliding scale basis, which means how much the study costs is going to depend on how much your client makes. the DRO is going to look at each party's income, look at their sliding scale, and give you a cost. You can also have a private entity do the home study. And if you do that, you want to make sure that you have an entity that's going to be LGBTQ plus friendly. For me personally, since technically people can discriminate against same-sex couples based on their sexual orientation, I have not had any home studies done through the DRO. I've always filed a motion with the court asking for specific permission to use a private entity to do the home study, an entity that I've worked with, an entity that I trust, and an entity that I know is not going to discriminate against my clients based on the sole fact that they're a same-sex couple. So that's really important to keep in mind. I know some of the other jurisdictions, they don't have a procedure on who does the home study, so you get to pick and choose who does the home study. So in the home study, the company is going to come out, they're going to interview the potential adoptive parent. They're going to sit down, they're going to talk to that person, they're going to figure out that person's financial history, they're going to figure out that person's personal history, they're going to watch the person with that child to make sure that they have a bonded relationship, they're going to make sure to inspect the home, make sure that the home is adequate for the child, and then at the end of the report, the people doing the home study are either going to recommend adoption or not recommend adoption. Sometimes the courts also require a health, social, educational, and genetic history report. These reports can also be waived. I believe in almost all of my adoptions that I've done, I've asked the court to waive those reports, usually because it's a step-parent adoption or we have one legal parent, and that parent already knows all of that information about the child. So there's no need to ask the court to file that report with the court. I've never had any instances where a judge has denied that request. So it is something that you can ask to be waived. If your client is adopting a child out of the CPS system, then typically there's already a report on file from that proceeding, and then you can usually just use that same report in your adoption proceeding. The other times that I've requested to have this report waived is when there's been a sperm donor that's been used. Again, the legal parent already knows all the genetic history. They've already seen everything when picking out their sperm donor. And also when there's an unknown father, because when there's an unknown father, typically that legal parent is not going to know the history of the other party. An amicus attorney is also required to be appointed in adoption proceedings. It's required in every case. It's required under our Texas Family Code. You can ask for an amicus to be waived. I personally have never had a judge waive an amicus. I think that most courts, when you file an adoption, a court is going to require an amicus attorney. The amicus represents the best interest of the child. They're going to do kind of the same thing that the people with the home study did. They're going to come out to the house. They're going to watch your client with the child. They're going to inspect the house. They're going to make sure that your client has a bonded relationship with this child. They're going to make sure that this child knows who your client is. And then at the end, they're going to say, yes, we recommend adoption, or no, we don't recommend adoption. All the cases that I've been in, all of my amicuses have recommended adoption. So I've not run into the problem where an amicus has said that they do not recommend adoption. If that were to happen, I'm not sure how a judge would react. It might be something that you just want to ask around about if you're concerned about it. Typically, you know before the adoption proceeding if your amicus is going to recommend adoption or if they're not going to recommend adoption. In Harris County, they work off of what's called a wheel system. So it's literally whoever's name pops up next is going to be the amicus that's appointed in the adoption. So as you can imagine, being an LGBT family, when you take that risk, you run the risk of, are you going to get an amicus that is okay with same-sex adoption? are you going to get an amicus that's not okay with a same-sex adoption? And unfortunately, in Harris, you don't really have any control over who your amicus is going to be. So before filing any adoptions in Harris County, I've always talked to my clients about that. I informed them about the possibilities, about the risk of filing in Harris, about the wheel system, and who's going to be the next name that has popped up. Again, I've been fortunate. Any of my amicuses that ended up on the wheel were very LGBTQ plus friendly. They had no problems with recommending adoptions for my same-sex couples. So for me, it has worked out where we were fortunate with that amicus wheel. In other counties, I've also done a lot of same-sex adoptions over in Bexar County in San Antonio. So when I would do my adoptions over there, their system was a little bit different in that you got to pick your own amicus. The court had really no say or no discretion or no thought on who was going to be your amicus. So I, again, had the same amicus that I worked on in all my same-sex adoptions over in Bexar County. I would just contact her, let her know I had another case. I knew that she was LGBTQ plus friendly. I knew that she was not going to not recommend adoption based on the sole fact that my clients were a same-sex couple. So once you have all of your paperwork together, you've now filed your adoption, you've got your home study complete, you've got your health evaluation on file if you need that, you have your amicus on board with the adoption. The court is going to set typically a pretrial hearing. I believe in Harris County, almost all the courts require a pretrial hearing, and this is before the adoption is done. So this is when the judge is going through the case, they're making sure everything is on file, they're making sure everything is correct, because judges don't like when you bring your clients down to the courthouse, everyone gets there, everyone's excited for the adoption, and then the judge has to tell you something's not right with your paperwork, we can't do the adoption today, you need to come back another day. So that pretrial hearings to make sure that all your paperwork is good to go, so that when you and your client show up to court, that adoption is ready. Everything's on paper, everything's good to go, and your child is going to get adopted that day. In adoptions, all the records are sealed. So once the adoption is complete, the court seals that record. Harris County has a form that you fill out prior to the adoption, allowing you to get certified copies of the adoption order. I have always submitted it simultaneously with my adoption order and have asked the judge to sign it on the same day as my order. That way, we're walking out of there. I know that in a couple days, I'm going to be able to go down to the courthouse to get a certified copy of the adoption order for my clients. Because what happens if you don't submit that, then later down the road, you have to file a motion to open the case, a motion to get special permission for the judge to allow you to get copies of those orders. So that's a really important step that you need to be sure to submit with your order. Again, in Bexar County, they would do it a little bit differently. Your judge would sign your order. You physically take that order. You go down to, they have a records room just for adoptions. You take it down there. They're going to make copies for you. They're going to give you certified copies, and you're going to walk out that day with your certified copies of the adoption orders. I've always told my clients, be sure to get as many as possible that day, because you don't know when you're going to need them in the future. And if you need them in the future, again, you have to file that motion to get special permission to get a copy of the order. So are there any alternatives to adoption? I have heard of people filing other motions, particularly a petition to establish parentage. So as we all know, same-sex marriage is now legal in Texas. And so some parties don't want to go through the adoption process because their thought is, hey, we're married, we've used a donor, we're both parents, we shouldn't have to adopt, we should be entitled to the parental presumption under the Texas Family Code. So instead of going the adoption route, they file a petition to establish parentage. And essentially, they're just asking the court, hey, we recognize we're both parents, this child was born during the marriage. Can you just sign an order establishing the parent-child relationship between the non-legal parent and the child? I think this may only be proper if the parties are married. I have attempted this in Harris County when the parties were not married. I represented non-bio mom. We filed a petition for parentage. And even when my client, non-bio mom, and bio mom were in agreement for the court to establish parentage, the court still denied it and went with our alternative relief of just a SAPSER. So again, I don't know if all courts are going to be willing to grant it, but it may be an alternative to filing an adoption and having to go through the home study, the amicus attorney, any hearings. So that may be another option to adopt, an alternative to adoption. Another alternative may be, can you file a declaratory judgment? So again, I think it may only apply if the couples are married, but you could potentially ask the court, hey, can you just sign a judgment declaring that this non-legal parent is actually the parent of this child? I don't know if a court would grant it or not, but my concern is that if you filed a petition to establish parentage, or if you filed a declaratory judgment, what's going to happen in the future if these parties break up and now someone tries to contest that order? Unfortunately, I don't think that there's any Court of Appeals opinions on this specific issue. So we don't know what would happen. I don't know if in 2 years they have this order declaring parentage, these parties are now breaking up, and the bio parent says, well, judge, that was a void order. And if the judge agrees with them, now the non-bio parent is left with no protection. So I think that still adoption is the best option. I think that it's really the only way to ensure that your client is going to have legal rights to this child. And since there's only a 6-month period that you can contest an adoption, you don't have to be so concerned down the road if someone comes back and tries to say that that adoption order is void. In an adoption, your burden of proof is best interest of the child. This allows the judge to take into consideration the prospective adoptive parent's sexual orientation. Again, this is kind of a scary place to be for LGBTQ plus couples because you don't know what's going to happen. Best interest of the child is a really hard standard to overturn on appeal. It is, I think, the hardest to appeal because if there's any facts to sustain the judge's ruling, or if there's any facts to support the judge's ruling, the Court of Appeals is going to sustain it. So before you file the adoption, it's really important to know the county that you're filing in. It's really important to try and do as much research as you can on the judge that you're going to be in front of, because if the judge denies that adoption and you want to appeal, the judge can deny the adoption based on your clients being a same-sex couple. And if there's any other fact outside of that, the Court of Appeals can sustain that denial of the adoption. And that's important because if your client ever wants to adopt in the future, in those home studies are going to say, yes, this person has been denied previously for an adoption. So in filing an adoption, there's a few unique issues that come along with it, venue being one of them. So venue is the place, where do you file a lawsuit? Generally, in an adoption, it's in the county where the petitioner resides, or it is in the county where the child resides. Even if there's a court of continuing exclusive jurisdiction, adoptions are one of those caveats where you don't have to file in that court. You can still file in another court. You are not required to file an adoption in a court of continuing exclusive jurisdiction. The good thing about venue is it can be waived. So that's how I was able to do a lot of my adoptions in Bexar County, because my parties agreed to waive venue for Harris and we went over to Bexar County. So if you're in a jurisdiction where it may not be LGBTQ plus friendly, or you're concerned that your judge is going to deny an adoption based on the fact that your client is in a same-sex relationship, then maybe you look into somewhere else that maybe is LGBTQ plus friendly and where you would feel more comfortable filing your adoption there. Another unique issue in adoptions in same-sex couples is a known donor versus an unknown donor. Anonymous donors, these are typically used when the child's conceived via assisted reproduction. Sperm is provided to a licensed physician to be used for assisted reproduction. And under our Texas Family Code, the sperm donor is not a parent. So that leaves you with one legal parent and no second parent's rights to terminate. So our code has given us guidance on what that is. So there is no question that an anonymous sperm donor is not a donor. But what happens when you have a known donor? You know, in my area, I had a lot of clients where they would have a male friend that would donate sperm directly to them, and then they would basically do at-home insemination. Under our Texas Family Code, this is not a donor. This is not a donor, which means that this man could potentially have parental rights. So what I typically did is a lot of times I was involved prior to the donation of sperm. So I would always make sure that my clients had some kind of sperm donor agreement in place, saying that it's everyone's intention that this donor is not going to be a parent. He is only going to be a sperm donor in accordance with the Texas Family Code. And because our law was unclear about sperm donors, we don't know if a sperm donor can even be a donor under the code. And you don't want your client to be the first one to take that to court to make case law and ask the judge to answer that question. And after the child was born, I would always have that known sperm donor sign a voluntary relinquishment. That way we would still terminate his rights in the adoption, and there would be no questions down the road of whether or not this man could come back and try to establish his paternity. It's language that I would build into my sperm donor agreements, saying once this child is born, if we ask you to sign a voluntary relinquishment, you agree to sign it. I never had any issues, and everyone was happy to sign off on the voluntary relinquishment. And then we would take it down to court. The judge would terminate his rights and then allow my clients to step in and adopt that child. You also have egg donor agreements happening in same-sex couples. So technically, under the code, an egg donor is not a mother. Since it's not as simple for a woman to provide her egg to someone else, this is typically done through a licensed physician. So the water is not as murky when you have an egg donor as it is when you have a sperm donor. However, I have done cases where I had a female couple and they took one partner's eggs, had it fertilized, and put it into the other partner. So now we had a genetic mother and we had a birth mother. So under our Texas Family Code, without a gestational agreement, that there is an unrebuttable presumption that that birth mother is the mother of that child. But in this unique situation, we also had a genetic mother. So what can you do? Our code says that if you can establish maternity between a child and a parent. So could we have filed a petition to establish parentage? Probably so, but we decided to go the safer route and file for an adoption. So what we did was we did a basically cross adoption. We had both partners adopt this child. That way there was no question in the future as to any of the legal relationship, since we had one genetic mother and we had one birth mother. So at the end of the day, they both adopted this child, even though they each had some kind of biological relationship to this child. Texas also allows same-sex couples to put their name on the birth certificates. I've had a lot of people tell me my name is on the birth certificate, I'm a parent, I have legal rights. I can't tell you enough, that answer is wrong. Being on the birth certificate does not establish any kind of parent-child relationship between your client and a child. All it is them putting their name on a birth certificate. It doesn't give the non-biological parent any rights to this child. Adoption is still necessary. The only thing is that at the end of the adoption, now you don't have to follow up and have your client's name put on that birth certificate. But just because your client's name is on the birth certificate, it does not establish any kind of parent-child relationship. It's very important for people to understand. It does not make them a parent. Texas does not recognize them as a parent, and they still must proceed with adoption. So the big question that still kind of lingers in Texas is, what about a parental presumption? And this is every lawyer's favorite answer. It depends. It depends on what jurisdiction you're in. We have no answer to this question. The courts are not uniform on this issue. Under Obergefell, it says that same-sex couples are entitled to the same benefits as opposite married couples. We've been told that we should read the code neutral when it says man and a woman, but the reality is I don't know that all courts are actually reading the code as man and woman, reading it as neutral. They're still reading it as man and woman. And so the argument that I've heard is, well, same-sex couples can't both be biologically related to this child, so there's no way that someone should be entitled to the parental presumption. If you're familiar with the case in re AE, it's out of Montgomery County. This was a same-sex female couple that were married. They went through assisted reproduction using an anonymous sperm donor, so there was no father. We had no issue with that. But the couple broke up prior to the child's birth. When same-sex couple became legal, non-bio mom filed for divorce and included a SAPSR in her divorce. She asked for the court to establish her as the parent. She argued standing based on the fact that she was entitled to the parental presumption because she had not lived with the child for the preceding 6 months, so she didn't have standing under a general standing statute. The only statute she could have possibly had standing under was that she was a parent. Like I said, she was asking for the court to establish her parentage. And what ultimately happened was Montgomery County said, you're not biologically related to this child. Therefore, there's no way that you can be a parent of this child. The parental presumption doesn't apply to same-sex couples. Therefore, I'm not finding you as a parent. The non-bio mom appealed the case. It went up to the Court of Appeals out of Beaumont. The Court of Appeals in Beaumont affirmed Montgomery County's ruling and said, yes, there is no parental presumption. Non-bio mom appealed it to the Texas Supreme Court. The Texas Supreme Court refused to hear oral argument on it. She filed a second motion to have oral arguments heard, and again, the court denied it. So we still have no answer on this that's uniform in Texas. I have heard if you go to other counties have said, yes, absolutely, same-sex couples are entitled to the parental presumption. In Cameron County, the Tretto case, again, this was a same-sex female couple. They used a sperm donor to have the child. The bio mom filed for divorce, arguing that the non-bio mom was the parent based on the parental presumption. So now we have a bio mom who's arguing for the parental presumption, whereas in re AE, we had a non-bio mom arguing for the parental presumption. So in the Tretto case, the trial court confirmed that the parental presumption applied, adjudicated non-bio mom as the mom, and ordered non-bio mom to pay child support. The non-bio mom appealed, and the Court of Appeals affirmed the trial court's ruling. So now in Cameron County, we have a parental presumption that applies to same-sex couples who are married. I've also heard that Bexar County has applied the parental presumption, and that Alston County has applied the parental presumption. Again, so it's really important. If your clients are married, there may still be no parental presumption in the county that you're in. That's why adoption is so important, because we don't know what the court is going to do. And your client doesn't want to be the first person to answer that question. An interesting case that has come out recently is in re TER out of Texarkana. And in this one, non-bio mom filed for an adoption over the objection of bio mom. So these parties were in a relationship, they were divorced, they had a SAPSR in place, and once the SAPSR was finalized, non-bio mom filed a motion for adoption. Bio mom contested the adoption, said she didn't think it was in the best interest of the child. Non-bio mom had her home study done. She had her amicus. The home study recommended adoption. Her amicus recommended adoption. And at the end of the day, the court found that it was in the best interest of the child for non-bio mom to adopt the child, even over the objections of bio mom. Bio mom appealed, took it up to the Court of Appeals, and the Court of Appeals confirmed it, confirmed the contested adoption. But again, that's a scary place to be because you don't know if you're in a court where a judge is willing to grant a contested adoption. And the most significant case that has come out that I think really, really affects same-sex couples, and this case alone should be enough to scare every same-sex couple into running out immediately and filing for adoption, and that's in re CJC. This case was just handed down by the Texas Supreme Court in June of 2020. Although this did not involve a same-sex couple, it is very, very pertinent to same-sex couples and same-sex family relationships. What this case has said, I think everyone is familiar that the parental presumption in 153-131A applies when you have a SAPSR of a non-parent versus a parent. What the court said in CJC is that this doesn't apply to possessory conservatorship. Our code is silent as to possessory conservatorship. This is only applied to the presumption if you're asking for a non-parent to be appointed as a sole managing conservator or a joint managing conservator. There's also no presumption as to visitation. Our code is silent. What CJC found is CJC found that a fit parent presumption now applies to the appointment of a non-parent as a possessory conservator and awarding periods of possession and access to a non-parent. And the presumption is that fit parents act in the best interest of their child. So why is this important? This is important because not all same-sex couples are married. Not all families are united under marriage. Parents don't always adopt. So now is our law saying that unless a legal non-parent can overcome at least the fit parent presumption that they don't get visitation with a child that they've been a part of that child's entire life? We don't know the answer to that. Our Texas Supreme Court didn't answer that question. They didn't address that issue. We have no clue how to answer that question. The courts are now left to answer the question of how do you apply that fit parent presumption to a non-parent who has stood in loco parentis to a child. So if you want to go and be the first case to ask your judge to answer that question, I don't know that your client is going to want to do that. That's why it's really, really important that same-sex couples adopt, whether they're married, if they're not married. If they intend on being a family, they need to adopt to ensure that both of these parties' legal rights are protected. As Daniel mentioned, I'm currently in a trial right now, and my trial is dealing with this exact issue where it's a same-sex couple. I represent non-bio mom. We have filed a SAPSR. These parties were never married, and my client never adopted. So now we're arguing over how CJC is to be applied to these specific facts. And it's not a fun place to be. Had my client adopted, then we would be having a completely different conversation. But because she didn't, now we're in court asking the judge to make that decision. So it's a very important case that absolutely affects same-sex couples and, again, reiterates the importance of why they need to be adopted. So like I said, who needs to adopt? Married same-sex couples need to adopt. Same-sex couples who've used anonymous donors need to adopt. Same-sex couples who have one legal parent need to adopt. It's the only way to ensure that their rights are protected. Any questions?
That was fantastic. If you all want to put questions, you can direct message them to me and I can ask them, or if you put them in the chat to everybody, Ashley can see them that way. I guess while we're waiting for that, let me give everybody the CLE course number. It is 17 110378.
So judges are typically very happy to do adoptions. I think it's one of the only good things that come out of family law. I know it's one of the only clients that are happy to ever come see me in the office. Judges get very excited on adoptions. Some courts have adoption days once a month where they have everyone that's in the courtroom that's only there to be adopted. So that's always a happy day to be in court on that day. A lot of judges have animals to hand out to the children. They'll let you take pictures with them on the bench and in their robes. So adoption is a very exciting time. It's a very exciting thing to be a part of.
I guess it is a sign of the times. There's always a COVID issue that comes up, over the past year. Have timelines in the family courts slowed down as much as they have, on the civil side, or how have things kind of been working over the past year, especially with when the home visits are required for the home study?
So I had a home study done. Let's see, we filed in March of 2020. And we didn't have our home study completed until September due to COVID. And then at that time, the DRO, this was not an adoption, but the DRO, because they do home studies, was about 3 to 4 months behind because of the requirements of having to go to parties' homes and actually visit with the people in person. I think a lot of the judges are still doing things via Zoom. So as far as getting in front of the judge, that hasn't slowed down a whole lot. But the home studies were definitely backlogged because of COVID.
And since not many adoptions are listed on the Houston Volunteer Lawyers portal, especially for same-sex kind of situations, is there like a specific provider like Tony's Place or something like that where essentially the referrals would come from, especially for a pro bono kind of case? Is that something you're maybe familiar with?
I'm not really familiar with that. A lot of my clients came from word of mouth because the firm that I worked for was a very prominent firm in the LGBTQ plus community. But I don't think that it would hurt to kind of reach out to them. You can also take the classes to get on the amicus wheel or the ad litem wheel in the courts and maybe take appointments through them to kind of get your feet wet, figure out how it works and kind of work from one end of the adoption and then kind of put your name out there of, hey, I'm doing adoptions now. Because what I have found is with same-sex couples, they do want to go to people that are familiar with same-sex adoption, even though it works exactly the same. But because there's some unique issues, they want to know that you can talk to them about the unique issues.
Did you see that in the chats from?
Yeah.
Okay.
Yeah, so like I said, you might want to take the courses to get your ad litem certification, see if you can get on the court's wheels. The court's ad litem wheel, you can also do it in Harris County. There's 3 juvenile courts. That's how I started. I put my name on the ad litem wheels over in the juvenile courts and the family courts so that I could get some appointments from the courts, meet the attorneys that are doing these adoptions, and then just kind of built a relationship with them, letting them know what my intentions were.
And is there like a go-to CLE or some kind of publication that you found to be really helpful, or you would recommend that the ad litem through the county, that training?
Yeah, so there's a, when I took it, there was a CLE that was basically just for ad litems. It was an ad litem certification CLE that you took. and it told you what to do, basically the procedures of an ad litem. And then once you get in there, you kind of figure it out and the steps that you need to take. The code is very helpful of reading through the code of what your duties are.
That was fantastic. Thank you. Thank you so much for joining us to present this. There's a lot of great information.
Thanks. Yeah, it's a very interesting topic, especially because there's not a whole lot of answers. We have this great decision on an Obergefell. We don't have a lot of answers for same-sex couples and how it applies to children. So I'm still telling everyone, adopt. It's the best thing. It's the only way to make sure everyone is protected. You need to adopt.
Not seeing any new questions coming in. So I guess we'll say thank you again. Thank you so much for joining us. I've really enjoyed it, and I will give you back a couple minutes to jump back into trial mode.
All right, and if anybody has any questions about the process or anything, I don't know if Daniel, you have my contact information. If you want to let them know, if they want to contact me directly with any questions or kind of the procedures or how it works, I'm happy to talk.
Definitely, we appreciate that. And for anybody on the call, just reach out to me, or if you have Ashley's contact directly, or I can help connect you after the call. So everyone, thanks for joining us. This was our second family law topic of the bar year. If you didn't join us last month when Angela Oakes, my former law partner, is presenting on modifications, that's on the YouTube stream. This one is also going to be in the YouTube stream after a couple of days, so keep your eyes out for that. And we hope you'll join us on March 9th. That is our next CLE, which is going to be really entertaining. It's one of our favorite topics when businesses get sued, but it's in a specific topic area of human trafficking that businesses are starting to get sued for their involvement with human trafficking. So we have Ben Ritz at Thompson Coe, however you say that, he is an expert in insurance coverage litigation. So it's going to be a fascinating topic. Look out for the HYLA email from Lucy and RCP for that. We hope you'll join us. And Ashley, thank you again. Good luck with the rest of the trial. Let us know how it goes.
Will do. Thank you, everyone. Bye.